9 times out of 10, no way, right? We might insure it if we're certain that it's separate property. That's a pretty high standard to be sure that it's separate property. If there's any uncertainty as to its character, we would not insure without joinder. So what would if it's anybody in this room, just assume that we're not going to insure that, right? I mean, then it's one of those, if they really push you hard, say, okay, well, let me talk to the title company. But you always want to, what? Under promise and over deliver. So the last thing you want to do is be the person that told them, oh yeah, they'll probably do that and then we won't. So we might insure. Might usually in the title insurance business means we won't. but
right.
But just be aware of that. H and W are getting a divorce. H wants to deed the homestead to W so that she can close on a refinance without his signature. We won't insure this, right? Because Texas homestead law says that deeds between spouses are not valid and do not turn community property into separate property. The reason for that is actually unrelated to this. It's actually related to people trying to avoid liability, right? Because there are certain other properties that can't. So if someone's saying, well, I'm going to deed everything to you because I might have some liability or risk over here and I don't want any of that property to be subject to that liability or risk, you can't do that, right? So we won't insure that. Deeds between spouses are not valid and do not turn community property. If it's already community property, you can't turn it into separate property by deeding it to your spouse. Unless accompanied by a written agreement filed of record, and then that has to meet the requirements of the Texas Family Code. So I would just assume it's safe to say, no, you can't deed your property to your spouse and then have them just close on it. Wait till you're divorced would be my advice. Divorce decree signed on August 1st, 2013, and on August 15th, 2013, awarded spouse wants to sell the property. Okay, this comes up too. So there's 2 weeks after a divorce decree which conveys the property, right? And we'll get into in minutes what I talked about, which is sometimes divorce decrees they say that they've conveyed the property, but the legal, they don't meet the legal requirements that we have for determining its legal conveyance. But in this case, we're likely going to require joinder of the other spouse or a deed from the other spouse. Now, they can't deed it at that point, they're divorced, because divorce decree is appealable within 30 days of being signed, plus 10 days for mailing of the appeal. So really, you have 40 days after a divorce decree is signed as either spouse to challenge that decree or appeal that decree, which means that we're not going to sign, we're not going to insure without joinder within 40 days of a divorce decree. So that's actually a pretty common scenario and does come up a lot. You know, somebody says, okay, I just got divorced, I'm ready to sell this home and be done with it, like, let's go. Just assume that if it hadn't been 40 days since the date that decree was signed, that we're not going to close that without joinder of the spouse. Okay? Okay, W hires you to sell her house that she, quote, received in a divorce. Okay, you find that H and W got the $500 divorce. The decree fails to address the ownership of the community real property. H moved out 2 years ago. Could go back to the court, but not likely. So are we going to sign that? No, we're going to require a deed from H, as the two are co-tenants and both have an interest in the property. What's actually really, really common is that family lawyers aren't real estate lawyers. So they often use language in the divorce decree that seems just fine. And the most common scenario is they say, Tom Berry gets the house at 307 Nautilus Avenue, Lakeway, Texas, right? And then I'm really mad when the title company says, no, we're going to require joinder of Tanya Berry. Reason being what? What do we insure on? Legal description, right? So automatically, if you see a divorce decree and it's conveying the property by address, we're going to require joinder. We are, right? Because we're going to say, hey, either you need a new divorce decree that conveys by legal description, or we need, you know, one spouse. And in that case, we might even accept like a quitclaim deed. Like if the spouse will just sign something saying, I don't know what I own in the property, but, you know, there's, I don't mean to, you know, a lot of people, that the title companies in Texas don't normally accept quitclaim deeds, but there are some shortcuts sometimes we can do on that. But just know that if a client, or if you have a client who's in the midst of a divorce and you're talking to them and they're asking your advice, be sure they're talking to the lawyer and making sure that the lawyer understands that they need to put adequate language in there. Primarily, for example, if it's dividing up real property, that they're dividing by legal description. Okay. Keep in mind, separate property will not and should not be mentioned in the division of marital estate. So really, ideally, they're determining that during the divorce, and they're saying, okay, well, the purpose of a divorce decree is to divide community property. If it's already separate property, then it shouldn't be in there, because then they're kind of confusing the issue. A court does not have authority to divest a spouse of his or her separate property. However, a judge can award a lien against separate property in order to reimburse the community estate. And you do see that in divorce decrees sometimes. There's some kind of oldie lien or something in a divorce decree that says, hey, you own separate property, but you also owe your ex-husband or ex-wife $50,000 as a part of the division of this, so but you don't have it, so we're going to place a lien against that separate property. So sometimes we deal with, that's another thing that comes up. You represent a seller, and they're mad because we come up and say, hey, there's an oldie lien, and we have to take some of these proceeds and send them to the ex-spouse, and they're like, what are you talking about, right? So that's another weird one. The divorce decree only identifies the property by street address, and no deed has been filed of record. That's what we just talked about. What's the primary cure? Just obtain a deed from the divested spouse. Sounds so simple, right? But that's the scenario we're in all the time. We pick up the phone and call them, and they're like, oh, okay, well, game on, right? So secondary cure, we may accept recordation of the decree in the real property records if the address is sufficient to avoid future confusion. So there are scenarios where if our underwriter will say, you know what, that's a really unique address, and we can see from the the appraisal district's website and things, that's pretty rare, so I wouldn't rely on that. But there are scenarios where if we run into, and we're really making a risk decision at that point, if it's just, hey, this person is so intractable and so unreasonable and there's no way we can get this done, if we can convince an underwriter, and that's our job, is to convince an underwriter, hey, this is a sufficiently, there's no confusion about this address and it's sufficient to describe the property. Sometimes, more often than not, no, but sometimes they'll sign off on it. Okay, liens of the ex-spouse. Generally, the liens of an ex-spouse attached to the property if not addressed prior to the divorce. Someone might be able to claim an innocent spouse doctrine on federal tax liens, right? That's what FTL is. But it won't work if there's a joint return. So this does come up sometimes. If I have a federal tax lien, but my wife Tanya does not, automatically, generally, well, not generally, automatically that lien is going to attach to the property. So even if the property is part of a divorce, right, then that the federal government gets to step in and say, hey, we're owed our tax money. They can claim innocent spouse, right? Say, I didn't know about that tax lien. That's only a valid defense if they didn't file joint returns, right? So if sometimes married couples file separate returns, so there are some ways around that, but generally, for example, a federal tax lien is going to attach to a property. I won't even get into the case law. There's some case law about AJs. Does everyone know what an AJ is? An abstract of judgment. That's if someone gets a judgment against you, someone gets a judgment against me for a business debt I owe somebody or something like that, they can file, but they aren't able to collect it. They can file an abstract of judgment. You hear about those from closers all the time. Hey, did you know there are AJs on this file? And those are liens that sometimes attach to the property, sometimes not. There are ways to determine whether they do. One of those issues is that there is a relatively new statute that allows a homeowner to file an affidavit that releases a homestead from a judgment lien, an abstract of judgment, but it's a very specific notice period that you have to go through, and you have to take certain steps to do it. It's a 30-day process, and we always tell people, a few years ago we taught this in the legal update. If you took the legal update a few years ago when it came out, you need to use an attorney to do that. But sometimes people say, well, that's not my AJ, that's my ex-husband's AJ. And it has not, and this is my homestead, it has nothing to do with it. Then there's a process they can go through where they file an affidavit of record in the county saying, this is not my lien, this is not my abstract of judgment, and provided that the creditor doesn't come back and challenge that within that 30-day period, then we can proceed and use that essentially as an affidavit that it's not their AJ and we can insure against the property. But we're going to require they use an attorney to make sure they do it right. Prenuptial agreements. We don't like them. Okay. Prenuptial agreements cannot override the Texas constitutional requirement of joinder when it comes to homestead. So you cannot give up your rights to homestead through a prenuptial agreement. You can for other pieces of property and other things. In addition, there are all kinds of, particularly in Texas, there's all kinds of case law and multiple defenses to the validity of prenuptial agreements. That's why you do see a lot of like high-profile Texas divorce cases where they're challenging this is actually a state where challenging prenuptials is easier than it is in certain other states, right? Because we have such...
Someone owns a home and they've got a prenup and then they get married, that person that did not own that home has community property in that homestead even under...
If it's their homestead, if it's determined to be their homestead, they would have certain homestead rights. Now that doesn't mean... Oh, I guess my advice there is, that's not a question that you or I can answer. So what the advice you should be giving your client is, okay, that was separate property, you signed a prenup, right? Likely that it is separate property, but if then they went and lived in that home and established it as their homestead, then they may have homestead rights that might confuse the issue, and so they would need to make a determination about that before we could convey title and not have it be challengeable in a way that's going to make us concerned about insuring it, right? So the answer is it's probably fine, but you don't want to just assume it's fine. If they've never lived in it, it's not homestead, it's a whole different ball of wax.
You have a local attorney that if we run into this kind of stuff, we could use?
Yeah, we have probably 2 or 3 that we recommend. So if you run into those things, always call us, and then we've got ones that we know what they're doing. And again, they don't work for us, but we're just referring out to them. But we're actually, your escrow officers are the best people to get referrals for this kind of stuff, because we deal with it all day long. So we learn pretty quickly. Here are the people who know what they're doing and can get it done, and here are the people who don't. And more importantly, here are the people that aren't going to, bill your client to the, they're responsible, and they're good attorneys that aren't just trying to, they're trying to make a living, but it does cost money. You need to let your client know that. Get ahead of the game. So what are the final thoughts on this, and then we'll kind of go to a little discussion. Most important thing is just if someone says they have a divorce decree, get a copy and get it over to us. That cuts down on so much. The scenario is that nobody is happy about this kind of scenario, right? It's never a pleasant experience. I've never met anybody that had nothing but positive feelings about their divorce, right? And so it's not so much that we can change the facts, but what we can do is get ahead of it and set an appropriate expectation, which is, hey, let's look at this divorce decree. Here's some things that could be an issue, and I want you to know about them. Hopefully they're not, but the reason I'm asking for this is not because I want to dig into your personal business. I want to make sure that I can adequately advise you about whether or not we're going to need to involve your ex-spouse or not. And even though you might be certain what your divorce decree says, sometimes the language in them is a little ambiguous. Let's let the title company take a look at it, and they'll give us very clear and concise advice about what it is that they need to do. That's it. Get the decree to the title company, and then we'll start determining and then the thing that you can help us with is, let us know if you think the ex-spouse is going to cooperate or not, right? That's an easy question. Hey, commiserate with your client a little bit. Is this something, it's probably fine, but just in case, is this something where it's going to be okay for us to reach out to the ex-spouse? How would you recommend that we deal with this? They may say, hey, you know what, let's just get my lawyer involved right now, and let's have him or her communicate with his or her attorney. That's usually the better way to do it, right? So those are kinds of the things that I wouldn't worry too much about. It's not your job, and in some sense it's not even really my job to determine all of the facts of this is community property, it's not community property, this is adequate language, it's not. But we will help you with that, right? Any questions on any of that? Okay, I got you through there pretty fast. I'm happy to answer any questions. Any good jokes?
On the second home, if they, I guess like you said, if it was the only property they own in Texas, it's still considered their homestead.
For Texas law, it would be their homestead. So I guess what the answer to that is they need advice and counsel from a family law attorney about whether or not in their opinion, that's going to be deemed to be separate or community, but more than likely it's going to be community property, especially if they bought it together during the marriage, right? And even if it's a second home and they don't, if you own a single property in Texas, it's automatically presumed to be your homestead for purposes of Texas law. Okay. Unless it is truly a commercial property. There are some, like if it's, you own a warehouse and there's, there are other ways that you can determine, but even raw land, we had this issue come up. Everybody aware that the rights of redemption on tax foreclosures, right? So there's different time periods for redemption. If I lose a property to property tax foreclosure in Travis County, if it's my homestead, I have a 2-year right of redemption, right? Which means that if I can show up within 2 years, and that's why people that buy homes from tax foreclosures have a hard time getting title insurance, right? Because if there's a sheriff's deed to me, and I buy that, and it was, or you buy it and it was my homestead, I have potentially a 2-year period in which I can show up and pay my back taxes and redeem that property, right? Literally take it back. That's also why you can get properties cheap on tax foreclosures, because you're taking a lot of risk. If it's not homestead, I may only have a 6-month right of redemption. We had a property a couple of days ago, I think it might have been in Wendy's office over here, where our underwriters, all of our underwriters were saying, we will not insure that yet. And they were saying, well, I understand, it's been more than 6 months and it's raw land, it's an empty lot, right? There's no home on it. But the potential was that if that's the only property they owned in Texas, a lot or raw land can still be a homestead, right? They purchased it in a sheriff's deed about 8 months ago, and our underwriters, all of them, are looking at it going, hey, they could show up and challenge that for the next 2 years, we're not going to insure it, as an example.
So oftentimes I'll get a couple that's going to divorce, and one person says, and it's going to be a while, one person wants to stay in the house, and it's going to be a long time for the other person to do that. Is the only way to get that person off the title then would be just
Sell it.
refinance?
Well, but remember, they can't.
They don't want to sell. I mean, the husband wants to keep the house.
Then they need to both sign the refinance, and then convey. So in other words, refinance is not gonna take them off title if it's their homestead.
So there's no way to get them off title other than a divorce decree.
Right. If it's their homestead, that's right. Yeah. So there would be no way they could still refinance it as long as they both show up and sign. Sign the refinance documents, and then the divorce decree would take care of determining who gets the property, right? But they would still need to both consent to the loan in that scenario. You bet.
So you said refinance first?
Well, I said they could go ahead and refinance if that's important to them, right? But they're both going to have to participate in refinance.
There's also a cash out refinance, where they can get money from that end. And
Yeah, but they won't be off of title before the divorce decree, right? If it's their homestead, they can't deed homestead back and forth to each other and separate. All a refinance does is we don't even issue a new owner's title policy in a refinance, right? We just issue a new lender's title policy to the new lender, right? So it doesn't take anybody off of title to refinance. And they can't, if it was community property that is their property they purchased during the marriage, particularly if it's their homestead, they can refinance it even if they're in the middle of a divorce. They're not divorced yet, but they both say, yeah, let's go ahead and refinance it. And then when we go through the divorce, that property will be yours, and then you will be on, at that point, then it's deeded over to them, and then she would be 100% responsible for the loan at that point. But that would be the way to deal with it. Okay?
if they refinance, he signed that deed of trust.
Right.
Like the divorce decree later on?
Yeah, they could then make some, but then the lender might come back and want to recast the loan and put, and then take him off the deed of trust, but they're going to want to, there's no way for her to take him off of title ahead of the divorce, if it's their community property and their homestead.
Gotcha.
Yeah.
Can I ask
Sure.
you a question going back to judgment?
Yeah.
So I just had a deal where there was the seller, deceased husband, had a judgment on the property. The title company had it released, but they said it was a partial release. What happens to that when she sells the property? What does that mean, partial release?
Partial release just means they released it as it pertains to the conveyance of that property, is usually what
So
that
if
is.
she were to move forward, even though her husband said it was, she thinks it's his debt, even though they were married.
Right.
Because it goes about
Right.
badly. If she were to go forward and buy another property, she's moving out of state. So
Right.
if she were to buy it anywhere else, would they
Well,
be able to challenge?
No, they probably wouldn't be able to attach to that. Really, a partial release just means they've attached it to whatever property he owned, right? And they may have gotten a release as it pertains to that property, but basically that's just saying, but we're not releasing the lien from anything else that it might.
So they did seize her bank account,
Yeah.
but she had no money in there.
Yeah. Well.
So if she were to go open another bank account, is there the right to seize that as well?
Well, so she is, maybe, maybe not. I mean, that's a hard question to answer. She would need to consult with a probate attorney because it depends is the answer, right? So, if it was truly deemed to be his separate debt, and you know, like you saw, like she could, even in death, like there's sort of like innocent spouse doctrines. I didn't know about it. I had no participation in it, but that's not like it's not a cut and dry sort of a thing. It's actually a good sign that she got a partial release against that property. I'm surprised that did they require some kind of a payoff?
I don't think so.
Okay,
I
because
don't,
usually
I mean,
what?
they did ask the title company for the closing statement.
Yeah.
And I was objective of that. I just didn't think it was their place to be doing that.
Well, the argument they're making is you're getting proceeds out of this. We might be owed money out of this estate. We need to know where those proceeds are going. And usually, what people say is, I won't release. I'll give you a release against this property, but I want $10,000, right? And then I'll sign a partial release or whatever it is. So I don't, not knowing all the facts, it's hard to say what happened there.
I don't
But
know all the
yeah,
facts either. Okay, interesting,
yeah,
thank
you
you.
bet, no problem. Okay, let me grab this for Leanne.
Thank you, Tom.
Yeah, you bet.
So, to go back to my
Yeah, keep talking. I'm listening. I'm just.